Hello everyone, I welcome you all to this lecture. In this lecture, we are going to start fifth model, that is the last model of this subject, that is about the Information Technology Act. In this lecture, we are going to discuss Information Technology Act, its objectives, aim, scope of this act, some major concepts and important provisions. Coming to the IT Act, its introduction. Uh, in the contemporary digital era, electronic communication provides a cheaper, easy to operate and retrieve and faster processing of transactions. The Information Technology, in short IT Act 2000, is an important legislation uh, in this behalf that seeks to provide legal recognition for legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communication, commonly referred to as electronic commerce or e-commerce in short. It involves use of alternatives to paper-based methods of communication and storage of an information to facilitate electronic filing of documents with the agencies concerned. IT Act allows unrestricted monitoring of all electronic communications even for some offences. This act aims to provide the legal infrastructure for e-commerce in India. Though India lacks a full-fledged ICT framework for implementation of e-governance, yet IT per se is playing an important role to facilitate e-governance by giving legal recognition to and promoting online filing of income tax returns, corporate returns, etc. The Act extends to the whole of India and it is also applies to any offence or contravention thereunder committed outside India by any person or an organization. The Government of India has brought major amendments to the Information Technology Act 2000 in the form of an Information Technology Amendment Act 2008. The new version of the IT Act has provided additional focus on information security. It has added several new sections on offences including cyber terrorism and data protection. Department of Electronics and Information Technology under the Ministry of Communication and Information Technology concerns itself with the administration of the IT Act 2000 and other IT related laws. Let us have the IT Act aim and objectives. The Information Technology Act 2000 is an important law relating to the Indian cyber laws. It aims at promoting e-commerce and facilitating e-governance. The Act strives to achieve the following objectives. First one, to give legal recognition to transactions done by an electronic way or by use of the internet. Second one, to grant legal recognition to digital signature for accepting any agreement via computer. So here the digital signature we already understood. Digital signature is the digital code which is attached or affixed by a person by using his private key to an electronically transmittable file, and later the one who will be receiving this, that will be he will be using the public key shared by the person who signed for the verification, so that it is going to serve two purposes: the authentication and message integrity. So to grant legal recognition to digital signature for accepting any agreement via computer machines is the second objective. Third one, to provide facility of filling documents online, such as filling of income tax returns or corporate returns, etc. Next, fourth one, to authorize any undertaking to store their data in electronic storage. Uh, Next one, to prevent cybercrime by imposing high penalty for such crimes and protect the privacy of internet users. Next one, and the last objective is to give legal recognition for keeping books of account by bankers and other undertakings in an electronic manner. So these are the main objectives of an IT Act. Now let us discuss its scope, means the scope of the IT Act. The Act attempts to address the following issues. First one, legal recognition of electronic documents. Second one, legal recognition of digital signatures. Third one, offenses and contraventions. Fourth one, justice dispensation systems for cybercrimes. So means third one, offenses and contraventions. The contravention means where someone will be deviating from the rule set made by an government. And the fourth one, justice dispensation system for cybercrimes means we should provide justice to the victims by finishing the cyber crimes. That is what the justice dispensation system for cyber crimes. Now, there are uh, some things which are not coming under this scope. Means as per the section 1, provisions of this act shall not be applied to the following documents or transactions. Few examples: a negotiable instrument other than a check, maybe a power of attorney, uh, and a trust as defined in Section 3 of an Indian Trust Act 1882, a will as defined in the Class H of Section 2. Next, any contract for the sale or the conveyance of immovable property or any interest in such property. And next, any such class of documents or transactions as may be notified by the central government in the official gazette as per the Section 4. These are the some scope of this IT Act. Now, moving to in the next section, we'll discuss some major concepts covered in this throughout chapter. Some of the important terms used in the IT Act are listed here. So we'll have there are the several keywords I put it together in the bracket manner. Now, what we'll be seeing all these terms one by one. So means where the first key term is access, that implies gaining entry into or instructing or communicating with the logical, arithmetical, or memory function resource of a computer or a computer machine or a computer network. Next one, addressee is a person who is intended by the originator to receive the electronic record but does not include any intermediary. Here the intermediary is the person who will be the agent between the sender and the receiver, who will be acting as in between. But addressee is a person who is intended by the originator to receive the electronic record without such intermediary. Next, adjudicating officer means an officer appointed under the section 46 by a government. And next, affixing digital signature means adoption of any methodology or procedure by a person for the purpose of authenticating an electronic record by means of digital signature. Next, appropriate government means any matter uh, that is enumerated in the list second of 7th schedule to the constitution or relating to any state law enacted under list 3 of 7th schedule to the constitution, the state government, or in any other case the central government. So appropriate government may be either a central government or a state government. Now next, a symmetric crypto system is a system of a secure key pair consisting of a private key for creating a digital signature and public key to verify the digital signature. Next, certifying authority is a person or organization who has been granted a license to issue a digital signature certificates, which is coming under section 24 of an IT Act. Next, certification practice statement is a statement issued by a certifying authority to specify the practices that the certifying authority employs in issuing digital signature certificates. Next, the remaining things such as the computer network, computer resource, all are familiar to you. But even here in this context, computer refers to means any electronic, magnetic, optical, or other high-speed data processing device or system which performs logical, arithmetic, and memory functions by manipulations of electronic, magnetic, or optical impulses and include all input, output, processing, storage, computer software, or communication facilities which are connected or related to the computer in a computer machine or a computer network. Next, computer machine network, which implies the interconnection of one or more of the computers through the use of satellite or a microwave, terrestrial line, or other communication media, and which is also the interconnection of one or more computers through a terminals or a complex consisting of two or more interconnected computers, whether or not the interconnection is continuously maintained. Next, computer resource refers to a computer or a computer system or a computer network, data, computer database, or a software. And computer system refers to the device or a collection of devices, including input and output, support devices, and excluding calculators, which are not programmable and capable of being used in conjunction with the external files, which contain computer programs, electronic instructions, input data and output data that performs logic, arithmetic, data storage, and retrieval, communication control, and other functions. Now, data implies here a representation of an information, knowledge, facts, concept, or instructions which is being prepared or has been prepared in a formalized manner and is intended to be processed, is being processed, or has been processed in a computer system or computer network, and maybe in any form, uh, including the computer printouts, or optical storage media, punched cards, punched tapes, or stored internally in the memory of a computer machine. Next, digital signature. Digital signature refers to the authentication of any electronic record by a subscriber by means of an electronic method or procedure in accordance with Section 3. Electronic form with reference to the information refers to any information generated, sent or received or stored in media, magnetic, optical or computer memory, or even on a microfilm or a computer generated microfiche or a similar device. Electronic gazette that refers to the official gazette published in the electronic form. Electronic record refers to any data, record or data generated, such as image or a sound stored or received or sent in an electronic form, or microfilm or a computer generated microfiche. And next, information, meaning that includes the data, text or images or sound, voice, codes, computer programs, software and databases or microfilm, etc. Next, intermediary. I already told intermediary is the one with respect to any particular electronic message is any person who on behalf of another person receives, stores or transmits that message or provides any service with respect to that of the message. Key pair is in an asymmetric crypto system implies a private key and its mathematically related public key, which are so related that the public key can verify a digital signature created by the private key. Now, public key is used to verify the digital signature. Originator that refers to a person who sends or generates or stores or transmits any electronic message or causes any electronic message to be sent, generated, stored or transmitted to any other person but does not include any intermediary. Next, private key that refers to the key of a key pair used to create a digital signature. I already told the private key is used to create a digital signature. Next, public key refers to the key of a key pair used to verify the digital signature, which is listed in the digital signature certificate. Next, a secure system refers to a computer hardware or a software and procedure that is reasonably secure from the unauthorized access and misuse, and which also provides a reasonable level of reliability and correct operation. And secure system is reasonably suited to performing the intended functions and adheres to generally accepted security procedures. So these are the terms, major terms. In your exams, you may expect define the following terms. So that is why you keep these things in mind to study the further concept in the chapter. Next, we'll have the important provisions. Here in this section, we are going to discuss some important provisions of the Act. Uh, 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 I made there are the 7 important provisions. Let us discuss one by one. The first one is digital signature, and about the authentication of an electronic records, uh, how these digital signatures are helping. So a digital signature is basically a way to ensure that an electronic record or document such as email or a spreadsheet or a text file, etc. is authentic. The Act contains the following provisions in relation to digital signature. The first one is any subscriber may authenticate an electronic record by affixing his or her digital signature. Next one, the authentication of the electronic record shall be affected by the use of the asymmetric crypto system and hash function, which envelop and transform the initial electronic record into another electronic record. Next, any person by the use of a public key of the subscribers can verify the electronic record. The private key and public key are unique to the subscriber and constitutes a functioning key pair as per the section 3. Next, second one, electronic governance. Here we'll see how the legal recognition of electronic records can be done. E-governance is the public sector's use of an information and communication technology, in short ICT, with the aim of improving information and service delivery, encouraging citizen participation in the decision-making process and making government more accountable, as well as transparent and effective. The three main target groups that can be distinguished in governance concepts are government, citizens, and businesses or interest groups. Generally, four basic models of e-governance are available, namely government to citizen means a customer. Next, second one, government to employees. Third one, government to government. And the last one is intergovernmental, that is government to business. So these four basics models of e-governance are available. And here e-governance is said to be a public sector's use of an information and communication technology with the aim of improving the information and service delivery, means to bring the more accountability and make it a more effective way about the processes and the governance. Uh, Third one is electronic governance. Here we'll see how the legal recognition of digital signatures can be done. Digital signature is the electronic or digital equivalent of a physical signature. Just as a physical signature on a paper document establishes the origin of that document, a digital signature affixed to a digital document means a soft copy establishes the origin of that digital document. Digital signatures are considered much more secure and foolproof compared to that of the physical signatures. While the physical signatures can be easily replicated or forged, the technology behind digital signatures makes it virtually impossible to forge them. More specifically, in India, the IT Act provides the legal sanctity for using such digital signatures. Next one. Fourth one is use of electronic records and digital signatures in government and its agencies. Because of the higher security associated with digital signatures and many advantages associated with storing documents electronically, as opposed to the paper, the governments in many countries, including India, of course, have passed laws and regulations encouraging the usage of the digitally signed electronic documents rather than paper documents. In India, for instance, income tax returns, corporate returns, etc., are to be digitally signed and uploaded electronically. Where any law provides for the filing of any form application or any other document with any office, authority, or a body or agency owned or controlled by the appropriate government in a particular manner. And the law also provides the issue or grant of any license or permission or sanction or approval by whatever the name called in the particular manner. And the law also provides the receipt or payment of money in a particular manner. Then anything contained in any other law for the time being enforced, such requirements shall be deemed to have been satisfied if such filing, issue, or grant or receipt or payment, as the case may be, is effected by means of such electronic form as may be prescribed by the appropriate government. And next, digital signed and uploaded electronically. The appropriate government may, for the purpose of subsection 1, by rules prescribe the manner and format in which the such electronic record shall be filed or created or issued. And next, the manner or method of payment of any fee or charges for filing, creation, or issue of any electronic record under the class A of section 6 can be defined by the appropriate government. Next, fifth one is retention of electronic records, where any law provides that documents, records, or information shall be retained for any specific period. Then that requirement shall be deemed to have been satisfied if such documents, records, or information are retained in the electronic form, if the information contained therein remains accessible so as to be usable for a subsequent reference. The electronic record is written in the format in which it was originally generated, sent, or received in a format which can be demonstrated to represent accurately the information originally generated, sent, or received. The details which will facilitate the identification of the origin, destination, date, and time of the dispatch or receipt of such electronic record are available in the electronic record. However, these clauses does not apply to any information which is automatically generated solely for the purpose of enabling an electronic record to be dispatched or received. Nothing in the section shall apply to any law that expressly provide for the retention of documents, records, or information in the form of electronic records. Sixth one is publication of rules and regulations in the electronic gazette, where any law provides that any rule, regulation, order, or by law, notification, or any other matter shall be published in the official gazette, then such a requirement shall be deemed to have been satisfied if such a rule, regulation, or order, or by law, notification, or any other matter is published in the official gazette or electronic gazette. Provided that where any rule, regulation, order, or by law, notification, or any other matter is published in the official gazette or electronic gazette, the date of publication shall be deemed to be the date of the gazette which was first published in any form. A person has no right to insist on accepting document in an electronic form. Next one, the last one, power to make rules by central government in respect of digital signature. The central government may prescribe the type of digital signature, the manner and format in which the digital signature shall be affixed, the manner and procedure which facilitates identification of the person affixing the digital signature. The central government may prescribe the control processes and the procedures to ensure adequate integrity, security, and confidentiality of electronic records or payments, and any other matter which is necessary to give legal effect to digital signature. It is under the section 10 of an IT Act. So this covers some important provisions of an IT Act. Thank you.